no rational trier of fact could find beyond a reasonable doubt the state has disproved the affirmative defense of others, and therefore the court must dismiss all 4 charges. Specifically, Dustin was justified when he shot Caitlyn, and all charges must be dismissed. The state offered evidence that Caitlyn died from a gunshot wound to the head and that the gun that was shot was Dustin's and was found in Dustin's car upon arrest. However, the state introduced the defendant's own statements through Detective McLaughlin, which offer enough evidence of justification, and so the burden shifts to the state to prove it was not justified. Dustin told the state in his interview how and why he was justified. Specifically, he described Caitlyn refusing to leave his home. He said Caitlyn was getting more and more aggressive. Caitlyn told him she was going to take the kids away from him. Caitlyn told him she was going to call the cops and have him arrested. Caitlyn grabbed Elwyn and was not letting go. She was again threatening to take the kids. Caitlyn was saying she was going to take Valen and Elwyn back to Minnesota. Dustin tried to grab Elwyn and be like, hey, let go of Elwyn. And Caitlyn just wouldn't let go. Caitlyn had Elwyn in a bear hug, a 2-handed bear hug. Dustin tried to grab Elwyn a couple of times. He couldn't pull that much because he did not want to hurt Elwyn. Elwyn was yelling. Elwyn was crying. Caitlyn was holding Elwyn forcefully enough to cause her to cry. Dustin said he grabbed the gun, chambered it, and while grabbing Elwyn, pulled her back and shot. He said it was immediate. He said it was super fast. He said, right when I shot, it was just immediately I grabbed Elwyn. Dustin said everything was so fast, it really was like finger snapping, training, it was instant. He said it was like muscle memory. It was his training coming out. He said right when he shot, he grabbed Elwyn, ran out of the house, put her in the car. He sat for a minute talking to Elwyn. He said he was making sure that nothing had happened to her. He said he was checking to make sure she didn't have injuries. He said she didn't. He loaded the car up, got the kids in the car. He was thinking at some point I'm going to turn myself in, but first he was going to spend some time with his kids, and he drove toward Concord. New Hampshire 627-4, paragraph 2 says, a person is justified in using unlawful, deadly force against another person under 4 separate circumstances. And the defense argues that 3 of those 4 are applicable here. When he reasonably believes that such person is B, likely to use any unlawful deadly force against a person present while committing or attempting to commit a burglary. C, is committing or about to commit a kidnapping. Or D, is likely to use any unlawful force in the commission of a felony against the actor within the actor's dwelling. So here, paragraph B is met. Caitlyn used force against Elwyn when she restrained Elwyn in her arms while committing a burglary. She entered, or it remained unlawfully, in the building or occupied structure. She did not leave Dustin's apartment when he asked her multiple times. And she did not leave because she had the purpose to commit a crime. She entered and remained, refusing to leave Dustin's home while attempting to commit a number of crimes the court could find. Kidnapping, or 633-4, interference with custody. A person is guilty of a Class B felony if such person knowingly takes from the state or attempted interference with custody, attempts to take from this state or entices away from this state any child under the age of 18 or causes any such child to be taken from the state with the intent to detain or conceal such child from a parent. Caitlyn was threatening to do so. She was attempting to do so. She was refusing to leave the home or release Elwyn. Or the purpose to commit false imprisonment, or the purpose to commit false report to law enforcement by telling the police that Dustin did not have permission to bring Elwyn to Minnesota or to New Hampshire. Harassment, with the purpose to annoy or alarm another, communicates any matter containing or any threat to kidnap any person or to commit a violation of interference with custody. Stalking, purposely, knowingly, or recklessly engage in a course of conduct targeted at a specific person, which would cause a reasonable person to fear for his personal safety or the safety of a member of that person's immediate family, and the person is actually placed in such fear. And the course of conduct would be restraining and yanking back Elwyn. Theft by extortion. A person is guilty of theft as he obtains or she obtains or exercises control of the property of another by extortion and with a purpose to deprive him thereof. As used in section 2, extortion occurs when a person threatens to A, cause physical harm in the future to the person threatened or to any other person or to property at any time, or B, subject the person threatened or any other person to physical confinement or restraint. Attempting to obtain Dustin's money, extortion would be confining Elwyn. Theft by deception. A person commits theft if he obtains or exercises control over a property of another by deception with a purpose to deprive him thereof. Deception occurs when a person purposely creates or reinforces an impression which is false, in which that person does not believe to be true. Attempting to obtain Dustin's money, deception would be telling Berlin PD that he took Ellen without permission. So those are all under paragraph B, where she was committing a burglary. Paragraph C is also met, where the evidence shows she was committing or about to commit a kidnapping. Dustin told the investigators when she said she was taking the kids back to Minnesota to take them away from him. Evidence shows that she was about to commit a kidnapping by her behavior and her words. And paragraph D is met, where here Caitlyn was using unlawful force against Elwyn when she was restraining her in her arms, squeezing her while attempting to commit interference with custody in Dustin's home. So she was in his home, she was attempting to commit a felony level offense and using unlawful force. If the court disagrees with those above arguments, it can still consider the crimes of reckless conduct and endangering the welfare of a child. And the state has not provided sufficient evidence for a rational trier of fact to find guilt beyond a reasonable doubt with respect to either of those charges. Reckless conduct alleges that Mr. Duren recklessly engaged in conduct which placed another Elwyn in danger of serious bodily injury by shooting Caitlyn while holding Elwyn. 2 reasons the court must dismiss for insufficient evidence. 1, the facts don't show beyond a reasonable doubt that Dustin was holding Elwyn while shooting Caitlyn. The only evidence the state presented is what Dustin told Sergeant McLaughlin and what Dustin said. Right when I shot, it was just immediately I grabbed Elwyn. He grabbed the gun, chambered it, grabbed Elwyn, pulled her back out of the way, and shot. The state alleges that this action was reckless, even though we have also heard from McLaughlin's interview of Dustin that he is an accomplished marksman, a Marine, that he's won awards for his proficient shooting, he knows how to use a gun. There was no evidence he was impaired, that he was using the gun recklessly around Elwyn, that he pointed the gun at Elwyn. The state, in its opening, focused on the statement that his acts were deliberate. Dustin carefully aimed the firearm. He purposely pulled Elwyn out of the way. He made sure that she was not at risk. He aimed the firearm away from her. We heard that the gun he used has many safety features and cannot accidentally discharge. In terms of the risk to Elwyn, this is no different than if Dustin and a child were at a firing range and Dustin fired, not towards the child, but instead at a target. That would not be reckless. The presence of a child in the same general area that a gun that is fired is not, without evidence that the gun was aimed at or near her, rise to reckless conduct. And third, for the endangering welfare of a child complaint, Your Honor, the conduct or the evidence that the court has heard feels bad, but what the state alleges didn't happen, and what did happen is not a crime. In Re NK, 169 New Hampshire 546 defines what endangering the welfare of a child means. A person is guilty of endangering the welfare of a child when he knowingly endangers the welfare of a child under 18 years of age by purposely violating a duty of care, protection, or support he owes to such child. So the state's required to prove two things, that Dustin knowingly endangered the welfare of Ellen, and two, that he did so purposely by violating a duty of care owed to her. And so again, the evidence here is that Dustin grabbed Ellen from Caitlyn and moved her out of the way while simultaneously firing one bullet in Caitlyn's head. He said, "Right when I shot, it was just immediately I grabbed Ellen." He did not violate a duty of care. He acted out his duty to care, to save her from harm, to remove her from the situation. There is no evidence Ellen was endangered. Evidence is sufficient to prove endangerment if it establishes, and again, this is from In re NK, if it establishes that the offender engaged in behavior creating an actual and significant risk of injury to a child's welfare. The state didn't offer evidence of welfare beyond harm to the ear. So there was no evidence that there was any potential psychological harm or anything of that nature. There was no evidence that she was injured. She was complaining of her ear hurting. The doctor told us her pain was secondary to lateral noises. There was no evidence of perforated eardrum or trauma to the ear. There was no outward signs of trauma. Ellen appeared well-kept and well-nourished. That's what Dr. Robertson said. There was no evidence of the volume produced from the gunshot. We heard evidence of the amount of pressure it takes to pull a trigger, but no one testified how loud the gun was. And the state did not present evidence of how loud a Beretta 9mm pistol is when it's fired. And that's no different, Your Honor, I would argue, that when you take a child to a musical festival with loud music without ear protection. And also, as we know from the evidence that Sergeant McLaughlin provided on direct and again on cross, is that Dustin said, "I can see where this is going of like, could it be that I'm endangering Ellen by what I did?" And I would very much say no. And then Sergeant McLaughlin responded, "Yeah, just to kind of tighten that up a little bit more, you're an expert marksman of some sort in competition. So it's fair to say you knew you were not endangering Ellen." And Dustin responds, "Yes, I was not endangering Ellen." And to follow up, Your Honor, again, they have to prove the mental states of both knowingly endangering the welfare of a child and purposely violating a duty of care. Thank you.
Okay, Attorney Spicer.
Thank you, Your Honor. They asked that the court deny the motion. In the light most favorable to the state, there has been sufficient evidence provided for a rational trier of fact to find each element of the offenses charged. I'll note for the court, as this court is aware, it's the defendant's burden at this stage of the proceedings. I don't believe that they have met that burden and shown that any of the charges should be dismissed. I will start with the murder charges. The defense argued that there has been evidence presented of self-defense through the defendant's statement. I would not agree with that. At this point, I'll make arguments, assuming that to be true, but I would state for the record, I don't believe that that's true. The defendant's statement established that he told Sergeant McLaughlin that he killed Caitlyn Naffziger very deliberately, that he did so because she refused to leave his apartment, that he did so after a day of arguments about things that they had been arguing by his own testimony for months and weeks. None of the statements that he claims that Caitlyn made the day of the murder, that she was going to take the kids away from him, that she was going to call the police, are things that were new to him. By his own testimony, she had said similar or identical things to him before in other contexts, and at no point did he shoot her in the head. His testimony, I think, was pretty clear, certainly in the light most favorable to the state, that he killed her because she wouldn't leave. He wanted to put her and the kids in the car so that he could drive them to her Aunt Brenda's house. He was in the process of doing that by his own statement. He put Valen in the car seat and got her ready to go. He was trying to take Ella in so that he could do the same thing, so that he could get her into the car and get Caitlyn moving. Caitlyn refused to let Ella go, and she refused to leave. The clear import of the defendant's statements was that was why he killed her. And so, just for purposes of the record, I don't think this is disputed. With regard to second-degree murder, both the knowing and the reckless varieties, there has been sufficient evidence presented as to each element of those offenses, that the defendant caused Ms. Naffziger's death, and that he did so knowingly, and in the alternative, recklessly, with extreme indifference to the value of human life. The defendant has admitted that he pointed his gun at Caitlyn's head and fired it. He has admitted that he knew the bullet went straight through. He has admitted, in essence, that he was aware that his conduct would cause Caitlyn's death by pointing a gun at her head and pulling the trigger, particularly in light of his statements about his own expertise and his own experience with marksmanship and handling of weapons. So I don't think there's any argument there. I didn't hear anything from the defense about this. I'd ask that you find that the state has satisfied the elements of knowing and reckless second-degree murder. Again, keeping in mind that there has to be some evidence of self-defense before self-defense that shifts and the burden moves to the state. Understanding that the state does not admit that that has happened here based on the evidence before us. Even if that is the case, there is sufficient evidence at this stage in the light most favorable to the state where the rational trier of fact could find for the state. The case law on this is somewhat convoluted, so I don't want to misstate the standard, but I'm citing State versus Pennock here, 168 New Hampshire 294 at 307. It's a 2015 case. At the sufficiency stage, the defendant must establish that no rational trier of fact, viewing all evidence and reasonable inferences therefrom in the light most favorable to the state, could have found beyond a reasonable doubt that the defendant did not act in self-defense. And that is an awkward formulation. But I would submit that there is certainly sufficient evidence before the jury for a rational trier of fact to find in the state's favor on that issue that the defendant did not act in self-defense beyond a reasonable doubt. I'll refer now to the facts. The defendant must actually and reasonably believe that he is acting in self-defense for any of the various forms of self-defense to come into play. He must actually believe it, and that belief must be reasonable. The facts here show the defendant did not believe he was acting in self-defense. The defendant shot and killed Caitlyn. He then packed up several days' worth of clothes, got in his car, and began driving. He certainly told Sergeant McLaughlin, my plan all along was to turn myself in. He never, in fact, turned himself in. He was arrested at gunpoint and pulled out of his car. The defendant spoke for 2 hours, as we saw, with Sergeant McLaughlin. At no point in that statement did the defendant tell Sergeant McLaughlin, I acted in self-defense. At no point did he tell Sergeant McLaughlin, I did what I had to do. I didn't want to kill Caitlyn, but I had to do it. Words to that effect. At no point did he say the word kidnapping. At no point did he say anything indicating he thought Caitlyn was kidnapping the children. This kidnapping is a fabrication that the defense has presented here. The defendant himself did not believe it, and that's what the evidence shows, certainly in the light most favorable to the state. There is no evidence that the defendant believed it was necessary to use deadly force to defend himself or another. The defendant told Sergeant McLaughlin, when asked, that Caitlyn did not threaten him, did not threaten Ellen physically. No physical harm threatened. The defendant's actions, I think, further, beyond what he told the police when he had an opportunity to tell them why he did what he did, and failed to say that he acted in defense, or acted in self-defense, or acted because he thought Caitlyn was going to steal his kids, or acted because he thought he was never going to see them again, or that he was necessary to prevent these things. The defendant called his mother and told his mother, in effect, I shot Caitlyn, you should probably call the police. He He didn't tell his mother I had to do it. He didn't tell his mother she was going to kidnap the kids. He said, I shot Caitlyn, or was to that effect, you should probably call the cops. In the light most favorable to the state, those are not the words of someone who believes that they have used deadly force in a justified manner. I'll go through the various forms of kidnapping. I'll put this on the record, Your Honor. Under State versus Monroe, and I don't have the site handy. Here it is. 173 New Hampshire 469. The defendant not only must provide an actual notice of defense in support of the defenses they intend to pursue, but there also has to be specific presentation of or sufficient notice of the factual allegations supporting the defenses. With regard to burglary and all those other flavors of kidnapping beyond, flavors of self-defense beyond kidnapping, I don't believe that was done. Walking through each of the varieties of kidnapping in 627-4, starting first with 2A, I addressed that. There is no evidence that the defendant acted because he reasonably or actually believed it was necessary to prevent the use of deadly force against himself or anyone else. He told the detectives that. 627-4-2B, the defense presented this court with a variety of crimes they claimed that Caitlyn could have committed or had the purpose to commit when she unlawfully remained inside of Mr. Duren's home. I can only imagine what the defense attorney would say if the state tried to charge someone in Caitlyn's position with burglary, based on the statements and the facts and the circumstances in this case. I'm not going to address each of those crimes. I don't think it's necessary. I don't think the facts support them, and certainly not in the light most favorable to the state at this stage. There is sufficient evidence to show that the defendant did not actually believe Caitlyn was committing a burglary, that he shot and killed her by shooting her in the head because he actually and reasonably believed that Caitlyn was going to had a purpose to commit theft by deception or false imprisonment or anything along those lines. So at this stage, in the light most favorable to the state, there is not sufficient evidence here, or there's not a lack of evidence that would allow this court, on the state of the evidence as it is, to dismiss the murder charge because of the defense arguments. 2D, 627-4-2D, defense counsel misstated the law. Defense counsel stated that under 627-4-2D, well, I'll state, the law says that a person is justified in using deadly force upon another when they reasonably believe that a person is likely to use any unlawful force in the commission of a felony against the actor while inside the actor's dwelling. The actor in this case is the defendant. So what that law actually says is that the defendant would have had to believe that Caitlyn was likely to use unlawful force in the commission of a felony against him. Defense counsel clearly claimed that he was going to use force against, that Caitlyn was going to use force against Ellen. That is not what the law says. It says the actor, the defendant is the actor. So the court should reject that. There's no evidence to support that, and there's certainly not sufficient evidence that the state cannot defeat it, and that there's that no juror could find for the state on this issue. With regard to kidnapping, I'm going to ask the court to reference the arguments that we made in our pleading filed yesterday about the law. I can summarize them here. I don't want to get too far into the weeds, but to come back to the actual and reasonable belief, the court knows what the defendant said in that statement that was put into evidence. That is the evidence of what the defendant, at this point, actually believed happened inside that apartment. I'll note also that at this stage, credibility determinations with regard to witness testimony must weigh in favor of the state when they're equal. And the court can assess the credibility of the defendant's statements or different parts of the defendant's statements, taking into account that he is providing his account of what happened, his story of what he told the police about what happened. With regard to kidnapping, as we stated in our pleading, Ms. Naffziger legally could not kidnap her own child under 633(1)A. Could not do it. Based on the interplay of 633(1)A and 633(1) and 627(4)(2)C, as we say in our motion, interference with custody is not a basis for the use of deadly force. That is what the defense is arguing. The defense is arguing that by telling the defendant or indicating that she wanted to take the children away from the defendant, they are claiming that that is a kidnapping. That is not something that legally Caitlyn could do. And to find that would be to add interference with custody to the list, to the narrow circumscribed list of circumstances where the law allows the use of deadly force, and that should not be the case. And with regard to each of the different versions of kidnapping, at this stage, again, the defendant did not tell the police that he killed Caitlyn because she was holding Elowen hostage. There was a reference to his training. The sergeant asked the defendant about if he had any sort of hostage training, and the defendant, it was somewhat difficult to see what he said or understand if he was giving an affirmative answer. He may have said, yeah, I had some sort of training. They would have covered that in some of his training. That was an opening for the defendant to say affirmatively and clearly, that's what I thought this was. This was a hostage situation. That's not what he did. He did not say that. So there is no evidence, certainly not evidence at this stage sufficient for dismissal, that the defendant actually and reasonably believed there was a hostage situation and that is why he killed Caitlyn. And I'll just add in here that ignorance of the law is not an excuse for the defense to claim at this point that, well, the defendant thought that Caitlyn was committing a kidnapping in ignorance of the law, which says that what she was doing or what he said she was doing was not a kidnapping. The law very clearly says that's not an excuse. The fact that he doesn't know what the elements of kidnapping are, he is mistaken on what a kidnapping is in the state of New Hampshire, that is not an excuse. The defense argument is built upon the idea that ignorance of the law is an excuse, and this court should not agree with that. 633(1)(1)A is the ransom hostage situation. I'm not going to address that any further. 633(1)B says that there's a kidnapping if someone confines a person to avoid apprehension by law enforcement. There's no evidence that that's what was happening here, and defense has not claimed that. 1C, to terrorize anyone. Defense has not made that argument. I don't think there's any evidence that Caitlyn was confining Elowen by holding her in her arms for the purpose of terrorizing Elowen or terrorizing the defendant, causing him alarm or dismay. And 633(1)(1)D would require that the victim confined, or Caitlyn confined Elowen for the purpose of committing an offense against Elowen. That is not, there's no evidence that Caitlyn was intending to hurt Elowen. And in fact, the defendant disproved that. He said, yeah, she was not threatening to harm Elowen. As Sergeant McLaughlin testified, the defendant told him Elowen was yelling, but the defendant said it was a combination of things. It was not just because Ms. Naffziger was squeezing her or holding her so hard that she screamed. It was also because of the yelling. So I want to clear that up. So that would be the state's argument with regard to the two murder charges. The elements of those have been met. There is sufficient evidence for the jury to find the defendant guilty beyond reasonable doubt on knowing and second-degree murder charges. There has not been evidence of self-defense sufficient for the burden to shift at this stage for purposes of this argument. Notwithstanding that, there is sufficient evidence, or the state of the evidence at this point does not justify dismissing them on a self-defense ground because there is sufficient evidence for the jury or the rational trier of fact to find in the state's favor on the self-defense issue. reckless conduct under 631.3. The elements of that are that the defendant engaged in conduct that either placed or may have placed another person in danger of a serious bodily injury, and that he did so recklessly with a deadly weapon as a firearm. In this case, the defendant, by his own admission, grabbed Elowen and then fired a gun at Elowen's mother while holding her so close that she complained instantly that her ears hurt. Reckless conduct does not require actual injury. It does not require evidence of actual trauma or actual diagnosis of injury. In this case, we do in fact have the testimony of a doctor who said she sustained an injury to her ear. That was what the doctor said. The defendant used a deadly weapon, and that deadly weapon was a firearm. The defense argument focused on the fact that the defendant is an expert marksman, and there's no way that he would have shot Elowen while he was busy shooting Elowen's mother. That may be true, but in light most favorable to the state, I think it is certainly reckless to shoot a gun that close to a small child while holding her essentially in the other arm. The defense actually presented two factual scenarios here, claiming that maybe Elowen was not in his arms, and that by saying that he grabbed Elowen and ran to the car, she was not somehow in his arms. If that is what they're saying the evidence shows, then Elowen is somewhere within the room, not in his arm, not confined. I think that actually adds to the state's case that she's somewhere at large while he's shooting a gun. It is not just the risk of a gunshot wound to Elowen, however, it is a risk of any injury, including injuries to the ear or to Elowen's hearing. There is testimony about that in the light most favorable to the state. The motion should be dismissed at this stage because there is sufficient evidence for the jury to find beyond reasonable doubt before the state. With regard to endangering the welfare of a child, again, there does not need to be actual injury for the defendant to be found guilty. And we are talking about injury to the welfare of a child, not physical injury. The cases on this crime that describe other versions of this, where people have been convicted and those convictions have been held, speak of situations involving, a caretaker getting high or drunk with a child in the car, certainly while driving, but in other instances, just getting drunk or falling asleep and becoming inaccessible while a child who is 2 or 4 years old is in the home and unsecured in a crib, walking around in the home where things could happen. Those are factual scenarios that have supported convictions for this crime. The evidence here shows that the defendant shot Elowen's mother in front of her. Although he told the police that he didn't think she saw anything and he hoped she didn't, she told the doctor that mommy and daddy were fighting, daddy hurt mommy and me, and there was a lot of blood. In the light most favorable to the state, certainly it is clear that Elowen knows what happened. Elowen is aware that the defendant shot her mother in the head. She was in the room and she saw it. There does not need to be further testimony for there to be evidence sufficient at this stage that by shooting Caitlyn in the head, the defendant endangered Elowen's welfare. We are not claiming that he injured Elowen beyond by shooting her with a gun. But when we're talking about endangering the welfare of a child, psychological injury or psychological welfare comes into play, emotional welfare, and that is what we're talking about here. It does not have to be evidence that Elowen is actually in therapy or that she has actually been diagnosed with a mental health issue for it to be shown that the defendant endangered her welfare by doing things that he did. The dual standard here that the defense mentioned is the standard. Purposely violating a duty and knowingly endangered the welfare. There's a case on that addresses it pretty well. Defense cited INRI NK. That case, I think, discusses that standard in a good way. Also, State versus Bortner. I don't have the site, I just have the name, but BORTNER specifically discusses the interplay between knowing and purposeful, finds that that is not a legal issue. And Bortner talks about a failure to act rather than an affirmative act. But,
Cite on Vortner?
excuse me?
You have a cite?
I don't have one. I
Okay.
apologize.
No.
I don't have it on me.
Thank you.
But BORTNER, it's 150 NH. I forgot to
Okay, no, thank you.
write down the end of it. Knowingly endanger and purposefully violate. I don't think that it is in dispute that by shooting Elowen's mother in the head in front of her, that the defendant purposely violated the duty of care. He had to know, anyone in that situation would know, that that would seriously compromise and seriously risk danger to a child's welfare, psychologically and emotionally or otherwise. And purposeful violation of that duty of care that he owed to her. I think the knowingly engage in conduct speaks to the act. And we have already argued that the defendant acted knowingly. I think that's all the state has at this point. We ask that the motion be denied.
Okay. Just 1 second.
Your Honor, 150 New Hampshire 504.
504, thank you. Okay, thank you. Attorney Kate.
Just one comment, Your Honor. I think I said it in my motion, that the state didn't offer any evidence of psychological injury or trauma or anything. It's speculation based on what it feels like. There was no evidence. And I'll leave it at that.
Okay, thank you. In response to that?
No, I don't think it's reasonable inference that shooting a child's mother in the head would endanger their welfare.
Okay. Okay, after considering the arguments made by counsel, after considering the evidence that has been produced at this stage of the proceedings, after considering the defense's arguments and the arguments from the state, I'm going to deny the defense motion to dismiss with respect to each of the counts. In construing this motion, the court must construe the evidence in the light most favorable to the state. If there is evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, if there is evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, the motion will be denied, citing State v. Wong, 138, New Hampshire 56, 1993, State v. Burke, 122, New Hampshire 565, 1982, and State v. Reed, 114, 377. Citing from Reed, in order to prevail, the defendant must show that the evidence viewed in its entirety, giving the state the benefit of all reasonable inferences, was insufficient to prove beyond a reasonable doubt that he was guilty of the crime charged. Here, the court does find that the state has produced evidence from which a reasonable jury could infer guilt beyond a reasonable doubt, construing the evidence in the light most favorable to the state. The motion to dismiss is denied. A few comments with respect to the overall ruling. There was a couple points. First of all, I'm going to adopt the reasoning as articulated by the state with regard to the reasons why the court is denying the motion to dismiss. With respect to the arguments from the state, there were a few times when the state inadvertently used the word testimony referring to Mr. Duren as opposed to using the phrase statements. There was a few times when Attorney Spicer used the word statements and a few times when he used the word testimony. Just to clarify, I'm considering the statement of Mr. Duren as referenced in the video and not any testimony, because that was not testimony under oath. So just to clarify, with respect to my reliance upon the arguments advanced by the state, anytime that the word testimony was used, I'm simply substituting the word statement for that as part of the overall argument. With respect to the individual arguments under 627.4, Roman numeral 2, at this point in the proceeding, I would find, once again, at this point in the proceeding, I would find that there has not been evidence relative to subparagraph A or D. There has been some evidence with respect to subparagraph C, and I will even indicate that there has been some evidence with respect to paragraph B, although that would be tenuous. To the extent that the burden has shifted with respect to C and arguably B, I would also find that no reasonable trier of fact could not have found that the defendant, that no reasonable trier of fact could have found that the a defendant did not act in self-defense, if I'm arguing that double negative correctly under Pennick, I believe it is.
Yes.
Under Pennick, I'm trying to articulate the correct standard to deny the motion to dismiss, indicating that a reasonable jury could find under the that no rational jury under the circumstances could not find that the defendant acted in self-defense. It's a difficult standard relative to double and perhaps even triple negatives, but I'm denying the motion on that basis. So I believe that that takes care of the instant motion that is before the court. Attorney Kinney,
Yes, Your Honor, I think so.
anything further?
No.
Okay. Attorney Spicer, anything further at this time? No? Okay.
I think he's indicating no as to that motion, Your Honor, but we do have an additional
Okay.
motion that I don't know if it's now that the court would like us to renew it.
Okay, one second. Attorney Kinney, any further motions at this point?
No, Your Honor.
Okay. Attorney Durand?
Your Honor, at this time, the state is renewing its objection to the proffered testimony or proposed testimony of Brenda Plumundon and/or Shannon Spurgeon. The state notes that despite the court's indication that Ms. Spurgeon's testimony would be cumulative, she has been subpoenaed and is present along with Ms. Plumundon in order to be available for defense testimony. This objection is to any testimony of either of these witnesses related to any plan that they purportedly or reportedly discussed with Caitlyn Naffziger. Your Honor, the court ruled following the state's initial motion to preclude this and following a hearing on that motion that you would allow the testimony, but you further held that Ms. Plumundon would only be able to testify as to her understanding of any such plan or discussion. You indicated that she must focus on the what rather than the why, without being able to testify as to any statements of Caitlyn Naffziger or as to the reasoning behind the discussion or the plan. In making that determination, the court has found that apparently, based on some level of fairness argument or and cited to the court's reading of the defendant's transcript to provide evidence that the defendant was aware that there was a plan between Ms. Plumundon and Ms. Naffziger, and that supposedly that Ms. Plumundon will be testifying to that plan, but the court believed, based on its reading of the transcript and based on some level of a value of fairness, that Mr. Duren was somehow aware of this plan, which even defense has described as a secret plan that the defendant was unaware of. The state, as it's expressed in its motion for reconsideration, believes that there is no indication that the defendant had any knowledge of this plan and that he would need to have knowledge of such a plan, or at least of the desired result, in order for this information to be admissible. He would have to know that Ms. Plumundon was involved. He would have to know that the details of what they intended. In its ruling on the state's motion to reconsider, the court made it clear that you were allowing the use of this material in order for the defense to somehow impeach a statement made by the defendant. But the court indicated that it was a statement of the victim that would be impeached, specifically the victim saying she wasn't going to leave. But the state would point out that that victim's statement has only come to the court, been provided to the court through hearsay. It is the defendant's saying that the victim made these words or stated these words, and now the court is allowing the victim's own state of mind in to impeach the defendant's statement about what the victim said. And I hope that wasn't too confusing, but that's what we're left with. Your Honor, with respect to this, essentially the court has found that it would be fundamentally unfair to preclude defense from bringing up a plan that the defendant wasn't aware of to impeach a statement that he says the victim made while she was in his home and right before he shot her. So the court is allowing the testimony, but then further precluding the state from asking questions about the victim's actual state of mind in the 36 hours before her murder. The victim's state of mind is the basis upon which the defendant initially sought admission of this material. But by its own ruling, the court has said Ms. Plumundon can only testify to the what, not the why, and that the court has also precluded the state from talking about the reasoning behind the plan, the basis for the victim's state of mind, which is her statements about her fear, her concern, and the prior relationship that she had with the defendant that made such a plan necessary. Your Honor, the state is cognizant that the victim's state of mind includes potential 404B evidence. It doesn't make it any less admissible to encounter the admission of this plan. Under the arguments that the state has made, the state believes and continues to believe and believes that the evidence that has been provided thus far, including the evidence contained in the defendant's statement, means that the door has been opened. Defense counsel leaned in during their opening statement, indicating about the victim's aggression. They've argued it again in this motion. All evidence of the discussion between Ms. Plumundon and the victim, should the court be allowing any of it, all evidence should be admissible in order to provide the underlying rationale to cure any misleading advantage that the defendant will gain from this information. Again, the defendant had no knowledge of any plan, and this is something that they have now put forth as the actual basis for the defendant both having shot and killed Ms. Naffziger, and for the support for these arguments that she was going to kidnap the children, and now that she was going to be committing a burglary inside of the home. Your Honor, this is not proper impeachment. It's not proper impeachment of a statement of the victim. It is not proper admission of victim's state of mind evidence. It does not support or corroborate the defendant's state of mind at the time that he shot and killed Ms. Naffziger. Further, with the court striking any discussion or hearsay statements away from the testimony, the admission is not supported by Rule 806, which would be to attack Ms. Naffziger's credibility as to the statement that the defendant told the police she made. Your Honor, in order for then existing state of mind, motive, intent, or plan to come in, this exception does not include a statement to prove a fact, remembered or believed. And that's exactly how this is being used in this instance. It's not only being used to show state of mind, defense is actually intending on relying on it to prove the underlying self-defense claim that they have. That is inappropriate use of state of mind, it is an inappropriate reason for its admission, and with the limitations currently provided, it provides a misleading advantage to the defense that cannot be cured unless the court, if this testimony is allowed, which the state still believes it should not be, but if the court is allowing any of it, it's still the state's position that the door is open and that the state should be allowed to elicit any and all testimony of Ms. Plumundon with respect to the planning of this situation. And so the state renews its objection, renews its motion to preclude, and renews its motion to reconsider.
Okay, thank you, Attorney Duren. Attorney Kettle?
Yes, Judge. I would reiterate all the arguments made in our objection, written objection in our previous argument on this hearing, on this motion, and in our argument on the state's motion to reconsider, as well as the court's prior ruling. The court has ruled on this issue twice. There's been no new information, no change in the information available to the court when it made its ruling. A second motion to reconsider at this stage is not proper. The court's ruling is sound. This evidence is admissible under 8033, and because a reasonable inference can be drawn, as we've discussed at length previously, that Mr. Duren was aware of the plan. I'll note a couple of things. I think that the state is misciting 8033. 8033 allows a statement of the declarant's then existing state of mind, such as plan, but not including a statement of memory or belief to prove the fact remembered or believed. So if we were trying to introduce some statement about a past tense plan, something that like a statement that was made to Ms. Plumundon about events from months ago, then that would not be admissible under 8033. But because it's Ms. Plumundon's testimony about a current plan, it does apply under 8033. I'll just note a couple additional things. Again, this has been litigated at length. We've relied on the court's ruling. The court's ruling is sound. But the state argued a few moments ago that the kidnapping is a fabrication of the defense. I would expect they would argue that in closing, and the kidnapping is not a fabrication of the defense. Ms. Naffziger had this plan. Ms. Plumundon has told that to detectives, to our investigator. She sent a text saying, "Need me to help plan a kidnapping." And so if the state's going to argue that kidnapping is a fabrication of the defense, that's certainly a problem when there's evidence that that's not the case. The other thing I'll note is the state, I'll rely largely on prior arguments on opening the door, but the state state said the door has been opened because there's been evidence of Ms. Naffziger's aggression. The state introduced that statement. The state pressed play on a video that had a statement about Ms. Naffziger's statement, and the state cannot open its own door. So the court's prior ruling should stand.
Okay. Attorney Duren, any response?
No, Your Honor.
Okay. Satisfied with the record relative to those issues?
Yes, Your Honor.
Okay, all right. I'm going to deny the state's motion to reconsider on that aspect. I've ruled several times on this matter. I did rule that Ms. Spurgeon would be inadmissible, would be excluded.
Oh, yes, Your Honor. I'm going to be calling Brenda, so I'll talk to the court a little bit about that. Miss Brenda Plumondon is our witness, but Miss Spurgeon, Trooper Pratt, Arthur Booten are all here in case we need to call them for rebuttal purposes.
Okay.
Yeah.
All right.
I do have a request before Miss Plumondon comes in, Your Honor, but it's about her testimony. When it's appropriate.
And I'm just going over my notes relative to the state's. Okay, again, I'm going to restate part of the basis for my ruling is I believe that the state, in introducing the statement of Mr. Duren through Sergeant McLaughlin, it is clear that at several points in that statement, Mr. Duren referenced a plan. He wasn't sure of what was happening. He articulated several times, and I recognize that he was offering the statement to law enforcement at the time, after he had a period of time between the event in question and the time of his interview. Not a lot of time, but there was some time. I recognize that he was offering the statement and that he indicated to law enforcement that he was asking what was the plan as it relates to Ms. Naffziger being retrieved, so to speak, from his apartment in Berlin. In other words, was he going to bring her back to Hampton? Was someone else going to pick her up? There was a number of times in which Mr. Duren was asking what was happening to Ms. Naffziger, according to his version of events. And based upon the defense argument relative to the introduction of Ms. Plumondon, am I pronouncing it correctly? Plumondon?
I believe so.
Okay, I apologize if I mispronounce. But according to that, I'm allowing the defendant to bring her in to testify relative to the contours of that plan, not with respect to any individual hearsay statements of Ms. Naffziger, and not with respect to the reasons for it. I agree with the defendant relative to the 404B motion that was previously ruled upon as it relates to any conduct that is not currently before the court, and I don't think that the door has been opened. I agree with Attorney Kettles as it relates to the fact that the state cannot open the door itself. Whether that happens during the rest of the trial remains to be seen. That'll be subject to further discussion as we move forward. But as of right now, the purposes and the reasons behind my ruling still stand. Anything further, Attorney Duren, on those points?
No, Your Honor.
Okay. Attorney Kitty.
Yes, Your Honor, thank you. So, Ms. Plumondon is here. Well, I believe she is. I haven't seen her today, but okay. And she is prepared to testify. We expect her to be a hostile witness. This is difficult, I'm sure. Her family is here, has been here. And we are very concerned that something might be said to cause a mistrial. So I'm asking for two things. Number one, for the court to have a colloquy with her outside the presence of the jury to just let her know she's answering the questions that are asked and not going into details. Because I think there will be a natural desire to try to explain things. And I would like to be able to lead a very tight and specific questions to produce the testimony that you have deemed to be admissible. I will note that the state got to do that with Carolyn Campbell. We want to avoid a mistrial, and I think the chances are high that she will say something. And I haven't been able to talk to her about that, but I also don't know how much weight she'll give me saying those things. I think it would be better to come from the court.
Okay, thank you.
Your Honor, it's unclear to the state whether defense has actually spoken to or prepared Ms. Plumunden for trial testimony at all, let alone where this indication is that she's a hostile witness. Ms. Plumunden is here. She was provided with, I guess, Mr. Booten's report as far as I saw. She described it as a transcript when we were told what she received. That's all I know. It looked like Mr. Booten's report. I haven't spoken with Ms. Plumunden because she's a sequestered witness, but she's being called by defense. I'm not sure that they've spoken to her. It became clear during a chambers conference yesterday that they hadn't spoken to her about sequestration. And so I don't know how we're at the point now of saying she's going to be hostile. Defense counsel is calling her as a witness. They didn't take an opportunity to prepare her, and now they're attempting to say that she's hostile. There's no indication of that at this time, Your Honor. She's not a party to the case. Sure, her family is here. Yes, she has a relationship. Her niece was murdered, but that doesn't mean that she's a hostile witness in any way, shape, or form. I understand the defendant's concern, and I will note that the state was ordered to lead Ms. Campbell through testimony because of objections made by defense. Ms. Campbell wasn't a hostile witness in any way, shape, or form. Defense wanted to limit her testimony because they didn't want her talking about hearsay statements that, again, the state doesn't believe were inadmissible hearsay. They were her descriptions of her actions. There's no indication that Ms. Plumunden is hostile. There's no indication of anything at this point. She's just a subpoenaed witness that hasn't been prepared by the people calling her.
Your Honor, first, we got a Zwicker letter the other day from the state, so someone talked to her, but the consideration...
If I may interrupt really quickly, the Zwicker letter says Ms. Plumunden was asked 2 questions and provided the answers to those 2 specific questions, and that is it.
Okay, so you talked to her, though.
2 questions. What was Valen's date of birth? I do not know. Was Caitlyn Naffziger breastfeeding? No. Those were the questions.
611-2, C2.
That's what I'm looking at.
Okay. When a party calls a hostile witness an adverse party or a witness identified with an adverse party. And it is true that I have not specifically talked to Ms. Plumunden about her testimony. I have provided her the recording of her 2 statements that she gave to the police on March 1st and March 15th. I have provided her the transcripts of both of those calls. I have given her the report that Arthur Booten typed up of his interview with her. Those are what she has. I have not talked to her. I have given her the opportunity to ask me questions. But based on what she told the police on March 1st and March 15th and Arthur Booten, and the things that she said about the defendant and the reasons why the plan existed, it's very prejudicial. It will lead to a mistrial if it gets blurted out, Your Honor. So for that, there's 2 reasons that I'm asking the court to give a colloquy to her and allow us to leave so we can avoid that. And it would be great if she doesn't come off as a hostile witness and just gives, and would give us the information. I just think the risk is very high, and to avoid future litigation, I am asking that we be allowed to do that.
Okay. Understanding that there's issues relative to the preparation of witnesses and disclosures of various information, understanding that, Attorney Duren, do you have any specific response to those 2 specific requests by the defendant?
Your Honor, I'll defer to the court.
Okay. All right. Thank you. Okay. I think under the circumstances, I'm going to grant the defendant's motion to allow leading questions relative to this witness, and I will conduct a brief colloquy with her because of the reasons stated by defense counsel relative to those issues. The colloquy is going to be focused upon her understanding that she has been number one, that she has been subpoenaed here, and that she's going to be asked questions, and that she's instructed to, is she prepared to answer the question that she is asked? Are you prepared to answer the question that you are asked? And are you prepared to limit your testimony to the question that was asked and not to volunteer further information? Is that sufficient, Attorney Kenny?
And, Your Honor, I think it would also make sense to instruct her specifically in accordance with your order that we're talking about the what of the plan and not the why of the plan.
And finally, that she's not to testify about statements allegedly made by Caitlyn. That she can testify as to her perception, her understanding of what her understanding of.
Just a question for clarification as to why the state has asked so many times for the motion to be reconsidered. Is Ms. Plumundon then allowed to testify to the factual result of a statement that is a hearsay statement of Ms. Naffziger, or is she only allowed to testify to her portion of the plan?
Her understanding of what was going to happen.
And doesn't that include hearsay statements of Ms. Naffziger?
And I've already ruled that that relates to her understanding as to that, not relative to indirect hearsay. But she can't testify as to what Caitlyn said to her, but she can testify as to what she understood the plan to be. Anything further, Attorney Kenny?
No, Your Honor.
Okay. Attorney Duren, anything further right now?
No, Your Honor.
Okay. 10-minute break?
Thank you.
Okay.